We have an extremely experienced and knowledgeable panel this afternoon, and I'll introduce you to each speaker in the order that they will speak. But I'll take away one aspect of the moderator's job. So let me first start with Daniel Drewer, who is the head of the Data Protection Office of the European Police Office, so Europol. Daniel is responsible for policy and information assurance regarding the processing of law enforcement data at Europol and also the Europol DPO, Data Protection Officer. The next speaker in a logical sequence will be Diana Alonso Blas, who is also the head of the Data Protection Service and Data Protection Officer, but this time at Eurojust, the European Judicial Cooperation Unit in also Den Haag, like Europol, since more than 10 years. And she's also responsible for the development of the data protection regime at Eurojust. The next speaker will be Els de Bussa, who is the head of the Department of European Criminal Law at the Max Planck Institute in Freiburg. The Max Planck on Foreign and International Criminal Law in Freiburg, in Germany. And Els is specialized really in the area of European and international law enforcement and judicial cooperation in criminal matters, information exchange and data protection, and she has written widely in this area. Finally, the last speaker of today's panel will be Michael Olmsted, who is the senior counsel for the European Union and International Criminal Matters for the Department of Justice, serving in the US mission here in Brussels, the US mission to the European Union here in Brussels. And I think while you can of course access all the data of our speaker's CV online, I think the best way to summarize Michael's impressive CV is simply to mention that he has had 30 years of experience as a prosecutor who has in fact faced many a difficult decision of precisely access to a smartphone. Now, last but not least, our moderator, who promised us all, as speaker and chair, to keep this panel on time, interactive and extremely lively. Tobias Bräutigam is the senior legal counsel at Microsoft, and Tobias supports their Microsoft in developing privacy-compliant device. Thank you for that. And but Tobias is also researching quite widely before, in fact, he acknowledged and told me this morning, before going to work, believe it or not, the area of that we will talk about this morning. So every morning, some people have some jogs. He researched this area, and therefore I can give him the floor right now to have a proper discussion. Thank you.
Thank you, Mario. Yeah, so when you read the conference program, you see the title, obviously, and you see a case mentioned, namely Riley versus California. And while we, of course, all are getting up very early to write our next book, I think it might still be a good idea to briefly mention what this case is about, because it's a very fundamental case. But I'm only going to briefly address this, and then the other speaker, Mike will speak a little bit more about it. So Mr. Riley was arrested. The police searched him and they found a smartphone. They found a smartphone, and on the smartphone someone said, well, that guy might be in a gang, because he had some kind of imagery associated with the street gang, CK. It doesn't mean Calvin Klein, it meant in that context Crip killers, a gang in the area. Then they looked closer into that, and finally the pictures and they associated with a former crime, and he was convicted. Mr. Riley didn't particularly like that, and he challenged that the police used his smartphone in order to get to those pictures, and then arrest him and charge him with several crimes related to gang violence. Worry is a similar constellation. Also, in this case, it wasn't that smart of a phone, but it was also used by the police to connect him to a crime. The important point from the from U.S. American law is that the searches took place without a warrant. Now, why is this important? It's important because the Fourth Amendment says that, and maybe I should read rather than paraphrase, the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrant shall issue but upon probable cause supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized. Well, there wasn't a warrant describing those things. The Supreme Court of the United States in June 2014 came with this Riley decision and basically decided that a warrant is needed. There was a concurring opinion by Justice Alito with different reasons, but basically it was an unanimous decision on the grounds. So really interesting decision for you to read. Now, of course, we're here in Europe, and we cover the topic also, but in a different concept. In order to address the topic, I'm not going to repeat the speeches and the CVs, but I'm going to tell you a little way how you might get in your question. We will have two blocks. The first block will be on why is access to smartphones so important for police? And we hear from Europol and also from Eurojust, then how the information is used and how we can process it. After that, we already will have time for questions, but then I have to cut it off. I guess that's why Mario, shifted it. So I have to say no more question, thank you, goodbye, because we're going to go to the second block, which is what is the EU legal framework? Is it adequate, and how should it evolve? And there we proceed the same time. We have two speakers and then another wave of questions, and then we'll close at 3:15. Now moving to our first speaker, Daniel. Why is access to smartphones so useful for law enforcement?
Thank you. Yeah, my name is Daniel Drewer. I'm the Data Protection Officer of the European Police Office. And looking at this panel where I see at least 3 law enforcement officials, I hope that you have your tablets and your smartphones in the hotel, not with you here, because you never know what can happen. Well, of course, I asked myself why I've been asked to be the first speaker on this as a representative of the European Law Enforcement Agency, and I assume it is because it is the police officer on the field of the crime scene that is the one that is in first contact with the smartphone, when also with the suspect of an investigation. So, looking at the activities of the European Law Enforcement Agency. We, of course, and most of you will know this, we receive personal data from all national police forces in Europe and beyond. And this includes, of course, also the data that has been extracted from smartphones that were seized in the framework of a national investigation. I would like to take this opportunity to tell you that we see that the value for data that is extracted from smartphones that are seized on the crime scene got during the last years more and more important for the investigation. The data that we receive then from national law enforcement authorities is treated still in the same way as we treat all our data that we get. That means under the observance of a very strict and robust data protection regime. What does it mean? Not everybody of you might be familiar with the work of Europol. That means that all the actions that are performed by Europol on the data are audited. So all actions on the processing of this data that might stem from smartphones are audited for not only for the data protection officer that has the possibility to look at the legality of the actions taken on this data, but also for a supervisory authority that consists out of 28 national data protection authorities of the European Union who control the work of Europol. Most of the data, and I say most of the data because we also receive data from third states with whom we have cooperation agreements, so most of the data comes from member states' national police forces, and this member states' contributions have, of course, to follow the principle of purpose limitation. And then that it doesn't matter if this is data stemming from a smartphone, has been extracted from a smartphone, or has been gathered in another way during a national investigation. This is the one part of Europol that we receive personal data out of national investigations, and one task of Europol to analyze this data and give back the analysis reports to the national police forces. That is the one side of our activity. The other side of our activity is related actually to the forensic, to the digital forensic when it comes to smartphones, and that is, I think, also the reason why I've been invited for this, to speak on this panel. Europol, as an agency of the European Union, we don't have coercive measures. So the smartphones that we receive are seized on the basis of national law in the member states and are given then to Europol with the task for the forensic examination of this smartphone. And there we see, when I talk with my colleagues that are responsible for this part of the work of Europol, we see that there are, of course, different possibilities, technical possibilities to extract data from a smartphone. I'm not a technician, I don't know, I'm only a poor lawyer. But what I understood is the way you extract the data from this system is, on the one side, important when it comes to the data protection aspects to safeguard data protection compliance. But on the other side, also interesting for the investigator, because what does an investigator want? Does he really want all the data that is on the smartphone? And I think a lot of you that are sitting here know more in detail than I do how much data there can be actually on a smartphone and a tablet. Is it that when we get this request from national law enforcement, please have a look to this smartphone, is the request in most of the cases, I want everything that is on there, with geolocation data, mails, agenda, Facebook access, or is it more, well, I would like you to look at the parts of the data in this smartphone that are relevant for my ongoing investigation. With other words, do I want the bulk data, the mass data that is on every smartphone, or do I want the targeted data? And what we see out of our experience is that the vast majority of the requests go for logical extraction of the data, which is what delivers you basic data that is related to the smartphone for the reasons that I said to you, because that is useful for the national law enforcement investigations and is also readable for the investigator in an easy way instead of getting all the data that is on this smartphone. This is the operational side of it. The data protection side, of course, is that indeed not everything is extracted from the regarding to personal behavior, and not everything is instructed that might be technically possible to extract from a smartphone. So that is for the keyword of data minimization. I think it's interesting to know this. The Europol actions on the smartphone, they take place on the basis of a policy, and a policy that regulates in detail the forensic IT environment and the activities that we facilitate in our forensic IT team. That means that to ensure the chain of custody, a full image of the smartphone, for example, is taken. But then you could say, well, from a data protection point of view, or I'm the data protection officer, why it is necessary to get a full image? Well, it is necessary according to the forensic standards and the chain of custody to have this. If you then want to apply data protection standards to this, you have to regulate what happens actually with this copy that you have. Who has access to this? Is the access locked? For what purpose is this data used? Is it at all possible to use this data? We had recently, well, and last year we had an inspection of our supervisory authority regarding to our forensic IT environment, and it was interesting that one of the recommendations of the data protection supervisory authority was, in fact, to oblige Europol whenever we technically support member states, police authorities, to keep a full image of the smartphone. So it was a recommendation of our supervisory authority to develop a policy and to follow this policy to keep from the very beginning a full image of the smartphone, also later to see what has been exactly done with this smartphone, and if the result of this analysis of the data on the smartphone goes into the judicial procedure, that then there's a full documentation. I come nearly to the end, and that is, of course, what is the main question that has been asked at the beginning. Well, what is the value of the smartphone for law enforcement data? Well, What we see is, first of all, the data that we extract from smartphone can be an important cornerstone of any national criminal investigation where a smartphone is seized. The smartphone data does not only show car logs, but also can encompass location data that can be used. You can see if a suspect traveled. You can even see if a suspect at a certain point in time took a photograph with his smartphone. So all this is possible, and then that is clear. That is an interesting information for investigators that work on a particular case. And since the smartphones that are provided to Europol are seized on the basis of national law, we of course see that in some of the EU member states there are also detailed and dedicated rules for the possibilities of law enforcement to seize the smartphone. There's a development of policies around this, where I think the second part of the panel will give you some insight regarding the checks and balances that are inherent in these policies that exist. The last point that I would like to make, because I see that my time is finishing here for the first introduction part in any case, is, well, it is important to know that when Europol receives the smartphone, this smartphone has been seized on the basis of national law. And then the member state decides, after we provide, let's say, the raw data that has been requested back to the member state then decide what should happen with this data. Should this data be cross-checked with the Europol files, or should it not be cross-checked with Europol files? And the feedback that we mainly get from investigators, but also from my colleagues working in this area, there is not even the interest to have this sheer amount of data and to use the sheer amount of data and put this into one of the analytical files, because it's useless. It's simply too much data that can be gathered on the smartphone. The purpose is to provide the service to the member states, and the member states then, after having a look to the data that they requested, don't provide back to Europol the haystack of data, but the needles that are necessary to provide analysis on the data extracted from a smartphone. Thank you.
Thank you, Daniel. I think that was an interesting analogy with the haystack and the needle, and I also have some questions, but I'll keep them back till we come to the question time in a few minutes. I'm going to hand over now to Diana, Alonso, Blas. Now, the first word from Europol, why is that useful? Now we'll hear how is it actually used, how can Eurojust collect, and how do they process it? Over to you, Diana.
Thank you very much, Tobias. It's a great pleasure for me also to be here today in this panel, and I have to say I appreciate very much the fact that for once this panel talks about law enforcement with people of law enforcement in the panel, which often is not the case, as the one we had before lunch. Very interesting to discuss law enforcement with nobody working on the field discussing on the topic. But okay, I'm not a law enforcement person. I'm a data protection person working in the field of data protection for the last 20 years. And the last 11 years I've been working at Eurojust. And just to say in one sentence, Eurojust is like the sister organization of Europol. We are a bit less popular because we do the second part of the job, which is the judicial cooperation between judicial authorities of the member states. So we are working in a field in which there is a serious organized crime taking place in at least 2 or 3 member states, and we try to coordinate these investigations and prosecutions. So I think building on what Daniel said, it's obvious that the information you can collect from a smartphone is useful for law enforcement. I don't think we need to dwell on that. I think it's quite interesting, of course, if you can make connections between different persons being investigated through linking the same numbers that have been called traffic data to enabling maybe to look at locations of persons, location data, and so forth. And as I said, we deal with international cases in which 2 or 3 member states are involved. And sometimes this information might be the key to ensure that we are talking about the same person and that we are talking about the same group of people operating, and therefore those investigations can be coordinated and put together. So we are not such experts in analysis as Europol is. We don't have the same amount of means and resources because, as I said, we are coming after the police has done its work, and we are in the phase which comes after that. But in some cases, depending on the legal system of the member states, sometimes investigation judges ask Eurojust to help with analyzing some of the information they receive. And in that sense, our case analysis unit also plays a role putting together this information. And also we sometimes use this information in the context of what we call coordination centers, which it means in an ongoing investigation, judges and prosecutors are exchanging data using Eurojust, and in real time, actions are being carried out in member states. So people are being at that moment going into certain addresses, searches are being taking place in several countries at the same time, and the information comes to us in real time. And this is done only in a few cases a year. We do about 10 of these coordination centers, but sometimes the information that can be collected at that moment can be of real interest for the further investigation. So, in fact, I might also have to disappoint you here. We don't collect personal data on the smartphones ourselves, neither. It's not the situation. The national authorities collect this information, and when we receive it, it is because they have done it according to their national legislation and in accordance with the procedures that they have in that member state. So if a judicial warrant is needed, of course, we only receive this information if this judicial warrant is there. But it's not our task to verify that. We get it from the judicial authorities of that member state. We have to assume that obviously those judges and prosecutors of the member states have respected the rules when they give the information to us. And what can we process? Of course, if we look at the smartphones, there's a lot of useful and interesting information one could think of, but our task and mandate is relatively limited. And if you look at our legal framework, and I know we will talk about rules and legal framework later on, in our case, it is very clearly enumerated what we may process and what we may do. So if you look at Article 15 of the Eurojust decision, it basically says we may process telephone numbers, email addresses, and data referred to in Article 2.2 of Directive 2006, blah, 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 which basically is data, traffic data and location data, and related data necessary to identify the subscriber or user. So basically, we are talking about being able to identify a given person and being able to make those connections. As I said before, maybe we are talking about the same person who is operating in different member states, or persons connected to each other within the same criminal organization. So it's quite limited, it's what we do. And on whom do we process data? I think also in that sense, what we can do is also relatively limited. We may only process this information for persons who, under the national legislation of the member state concerned, are suspected of having committed, of having taken part in a criminal offense, in respect of which Eurojust is competent, or who have been convicted for such offense. So we are really talking about people being investigated or prosecuted. We are already at this phase, which is much more advanced than what the police work would be. In some exceptional cases, for a limited period of time, we may process other personal data related to the circumstances of the offense, but this is then in very specific cases. In that case, I have to be informed as data protection officer, and this is recorded in our case management system as an exceptional case. And should the data be referred to victims or witnesses, then we need a documented decision of at least 2 prosecutors of 2 member states at Eurojust, and otherwise we may not collect this information. So it's quite regulated and also limited in terms of what we may do with it. Further than that, our legal framework then applies in its entirety. As Daniel said, we also have a very comprehensive legal framework in terms of data protection, and then this applies fully to this information collected then. So we have all the additional safeguards, as I say, if we are talking about the special categories of data subjects, also including strict conditions as to how long this information might be kept. We have very defined rules on access to the information. We have data retention limits, which are also enforced automatically. So our case management system was developed already taking into account this idea of privacy by design. So all these legal requirements are enforced automatically. So when the time limit arrives, you will get the notification, and I, as data protection officer, also get this notification, and the data may only be kept if there is a very clear justification in accordance with the rules. Otherwise, the data are deleted. We also have, as Europol, complete log files, so every single action that takes place related to this information is documented and can be retrieved. And this is monitored actively by us, so the Data Protection Service is monitoring this on a weekly basis. We produce reports every week, and our supervisory authority is monitoring us in a very regular basis. Actually, we had the pleasure of having a full-fledged inspection this week from Monday to Wednesday. We had 6 inspectors spending 3 full days at Eurojust, and everybody was very happy and excited about this event, of course, as always. So we also have clear obligations to keep the information updated, relevant, not excessive, and so forth. So this is a continuous process. And as I said, all this has been enforced in our case management system. So basically, we try to take the approach which is very preventive. So a number of things which are not possible in accordance with the rules are not possible in our automatic system neither. So in that sense, it's better to do it this way. And as I said, we check every week to ensure that everything is happening in accordance with the rules. I will leave it here now, and I'm sure we will come back to some of these issues later on. Thank you.
Thank you, Diana. Now it's time for questions from the panel and then also from the audience. First, as a moderator, I'd like to kick the questions of the panel off in a way. Both Daniel and Diana have said in different ways that the data that's really useful is quite limited. So Daniel talked about, basically we're only after the needles, not after the haystacks. This is a bit different than Keith Alexander from the NSA, who said you need a haystack to have the needle. But this is, from this side, it seems like only the very pointed, also Article 15, telephone number, email address, identifying data. Those are the ones that the authorities look for. Now my question is, also as from the product development and someone who works in the mobile industry, there's a lot more data. For example, I'll give you 2 examples. First one is location. Location would think for me as a citizen and also some working there as extremely relevant, and I would like to hear if this is also relevant in your field. And the second one is maybe a little bit off, but where I see the mobile industry going is to provide a lot more services that were previously done by other devices. Well, location and the car navigation is one, but then also health. If you think there are a lot of smartphone manufacturers that provide something like motion data, we say, okay, now you take the steps, you have taken so and so many steps, maybe some of you in the audience already use that, running, and so, but previously you had these different watches and so on, there's still an own market for that, but also smartphones can do that, and can have health data. Is this even relevant, like a case to say, oh, this suspect is really unhealthy, or he has this and this heart rate, let's say, let's measure the heart rate, so we got him, or is that the fantasy? So the first is location, which might be a little bit closer, and the other one is the health data. Is that relevant? Yeah.
Well, when I talk to our forensic experts and I ask them what they actually do with the smartphones, then they tell me that the vast majority of the cases is this logical extraction of the data, and that excludes geolocation data. So that is what they, out of their daily praxis, could tell me. For the other point, yeah, I think the fact that there is more and more data available, including what you said, health data, where then would be the question even, can Europol process this in certain databases, because there's simply this prohibition for us to have this kind of sensitive data, I think makes just more clearer that if law enforcement seizes a smartphone, you have to be very careful to look what kind of data can be extracted from this smartphone, and it's not like the police seizes a diary. It's simply like that with a personal diary. It is a gold mine of data, and therefore the privacy, the laws that regulate the activities of the police must be, on the one side, look at the operational interest of the police, and on the other side, must look at data protection and provide a structured protection of personal data. So I cannot tell you in detail which data, yes or no. A priori would say everything is interesting for law enforcement, depending on the national investigation that is ongoing. Yeah, but the implementing rules must be clear when it comes to the fact that a smartphone has this incredible amount of data in there that, and even you know it better than me, the technical development adds features to apps on a daily basis.
Well, as I said before, in our case, what we may process is quite limited by law. So it mentions location data in as far as it is necessary to identify the person. So if by using the location data, the national authorities have been able to determine this is really the person who was in the right place at the right time and therefore he's the suspect, okay, this will be something which is mentioned in our file. But otherwise, I mean, it's not like in the movies that we will follow in real time where the guy is to go and arrest it. This is not our task. As to the second part of the health data, I mean, of course, there could be a potential that in a very specific case it could be of use. But again, well, in our case, I have never seen something like that. So, well, I think it could be rather unlikely.
Okay, thank you. Are there other questions from the panel?
I have more of an answer to that than
or answers, yes. Please, Mike.
I think in many cases we would find time and location data to be extraordinarily helpful. One of the things that surprises you if you do prosecutions of gangs is that they take pictures of themselves while they're committing crimes and they post them on their Facebook pages. Thank God. Anyway, and some of them carry them around in their phones. And if you have time and location data, you know that they are standing in front of a stack of cocaine and a pile of money at a particular place at a particular time. And since the job of prosecutors is to convince either a jury or a judge that this person sold cocaine at a particular place at a particular time, that kind of information is very helpful. Also, if you have 5 people who pretend not to know each other and you can show that they were all in the exact same place at the exact same time using their phones, calling the same kind of people, that may not be definitive proof, but it is very helpful proof. And that it's when you put up one little piece of evidence after another, that's how you convict people. So yes, time and place. We don't ask for every item of time and every item of place, but if we find photographs, for example, that are interesting on a phone, we'll try to find out everything we can about how it got to be there.
Thank you, Mike. Now, I want to turn to the audience, and first I have a question, so we get to, and then you can ask questions. So my question is, could you raise your hand if you work in law enforcement, in the law enforcement community? See? That doesn't seem to be an overwhelming majority.
One in the corner.
Yeah. Or could you raise your hand if you're a researcher who is interested in the topics of law enforcement access in this kind of questions? A few hands go. Are you double handling there? No. Okay, those are no two. Okay. Okay, and then all the others maybe, are you here because you're interested citizens or yes? Yeah, I guess so. Yeah, at least I'm also for that here.
Although
so
you don't have to tell anyone.
Yeah. You don't have to tell anyone, yeah. Okay, we have a few minutes of questions, and I see a question at the back, please, Katarina. Yeah.
Thank you. Laurent Bellet from the Joint Research Center of the Commission. I have a question regarding data. I would like to know the point of view of the panelists, if this data is personal data or not. We are collaborating with the colleagues of Daniel on some techniques in order to extract from a smartphone the fingerprints of the camera sensor. So it helps us to link some pictures to a specific camera, specific smartphone. So we have been able to demonstrate that if you have a database of pictures, some of these pictures might have been taken by this smartphone because you will retrieve in the pictures the same fingerprints left by the sensor of the camera. Will you consider this specific fingerprints a personal data? I hope I was clear enough. Yes,
thank you.
Well, I think, of course, you would do that. I mean, why would you want this data if it does not enable you to identify the person? So I think it goes back to the definition.
Yeah, so the answer is clearly yes, and I guess if we take the definition, if it can link to one, and if that's the purpose of the whole, then it's, yeah. We have a question here in the middle, and please follow the example of the first question. Keep it brief and clearly answerable. Thank you.
It's a lot of pressure. I shall try.
That's my job.
I had a question for Ms. Blas. First of all, thank you for your presentation. I think it's extremely useful that officials actually tell about the way they work. You were talking about Direction 2006. I guess you mentioned the Data Retention Directive, right? Does the annulment of the Data Retention Directive by the European Court of Justice, which pointed out that the complete absence of limits to the collection of data inevitably leads to a disproportionate interference with the right to private life, does that have a consequence for the legality of the framework under which Eurojust is actually processing personal data?
Well, indirectly, yes. I mean, obviously the directive did not apply to us. The directive applied to the national authorities, which were then entitled to retain this information. So obviously in the sense that they might not be able to have this information, this might impact us, but it does not have an impact in our rules, I would say. However, what you see is that then some of the member states are looking for other ways in which they could still retain the information. So it is maybe a side effect of the judgment. But for us, as I said, we only receive the information if the information has been legally collected in the member states. So if they may not do it anymore, well, obviously they may not provide it to us. That's the clear consequence. Yeah.
No, but I think the way I read the judgment of the course is that blanket data retention is illegal by definition because it can never meet the requirement of foreseeability that you have a precise scope. So I understand your answer, but I'm wondering how the law enforcement community of the EU is taking these considerations and these safeguards into consideration.
And I think it's good to wonder that about the framework, because this is actually leading to the second block. I see there are questions, but we'll have question time also at the end. I'm concerned a little bit about the time, and I think actually that else we'll answer all the question anyway. No, Else will also talk now about the legal framework, its adequacy, and a part of the legal framework is obviously also the data retention, or the fate of the data retention directive, let's say. Is the legal framework adequate, and should this legal framework evolve, and what are challenges? And without further ado, over to you, Else.
Okay, this is working. Thank you, Chair, and thank you to all of you who have sacrificed part of their Friday afternoon to join this panel, because I know there's some fierce competition with other panels. I have to be honest with you, I was a little bit puzzled with the topic of this panel at first, smartphones and law enforcement. There's a lot to say about it. And we had some scoping, we had some narrowing down of this topic. I was also humbled to see who was on the panel, because I'm the only academic here. And fortunately, now I know I'm not the only academic in the room, because many of you put up their hands when Tobias asked for researchers. And then you will know that academics can sometimes act like 3-year-old children who just discovered the meaning of the word why. And so I was wondering, why are we discussing smartphones here and not regular phones? What is so specific, what is so unique about information on a smartphone? And what is different about it than information in your wallet or in your pocket or in your purse? And after some thinking, I came up with 3 points. A few of those have already been mentioned, not only here today at this panel, but also in the past few days. The first of which is location data. If you were at the panel, an excellent panel, by the way, yesterday, down in La Cava on location data, you will have noticed that location data certainly is qualified as personal data. Also, the Article 29 Data Protection Working Party recognized that. Location data, thanks to the GPS function on your smartphone, enables to draw an entire pattern of movement, because a smartphone is usually kept on or in the proximity of your body and will travel with you. That makes it quite sensitive, but it also makes it useful, as you just heard the examples given here by the other speakers. Because it's personal data also means that it falls within the scope of the legal framework that you may be familiar with, Directive 95 when it comes to commercial activities, and framework decision, for now still, framework decision of 2008 when it comes to make it short, law enforcement purposes. Most of you will also be familiar with what is understood by the concept of purpose limitation, by the concept of necessity and proportionality, so I will not go into these concepts too deeply to save some time. The second point that I wanted to make, why are smartphones so unique and what makes them different, is, as was mentioned before, also the sheer size of data sitting on a smartphone, but not necessarily sitting on your smartphone. A considerable amount of data is sitting in the cloud, for those of you who use cloud services. And how is law enforcement supposed to react to this? It means law enforcement needs to cooperate with private companies, needs to cooperate with the cloud service providers. So first of all, we have to make the distinction between the data sitting on your smartphone and the data sitting in the cloud, which a few months ago was painfully illustrated by the hacking of the iCloud, and some Hollywood celebrities saw their private pictures that they thought were private and taken with their iPhone, thinking that these pictures were sitting on their iPhone, but they were stored in the cloud, which was hacked. I think a lot of people are still unaware, and I notice that myself when I use my smartphone, that I'm not aware of, am I looking now at data that is stored on my phone or that is stored in the cloud? There's a question of awareness here. But the topic was law enforcement and smartphones. So cooperation between law enforcement and private companies is certainly a topic here, and since the Data Retention Directive was just mentioned, I do want to make that distinction. The Data Retention Directive, one of the biggest problems with it was indeed necessity and proportionality, was the blanket retention, as was just mentioned. When law enforcement needs to go to the cloud provider to acquire, to obtain certain data, that of course is then, or should be linked to a specific case, to a specific investigation. That will not be the same as data retention under the directive. Under the directive, it was an obligation for telecommunication providers to retain these data just in case they would be needed in a future criminal investigation, which was a problem with necessity and proportionality. That will not be the case when there is a link between the data needed from the cloud and a specific investigation. Third point that I wanted to make, and I find by far the most difficult one to speak of because it is highly technical, and I have no technical skills. I have a hard time operating my own smartphone, but remote wiping and encryption of smartphones is a very significant issue for law enforcement. You may be familiar, for those of you who have an iPhone, you have this service that you can register to Find My iPhone, which is practical in case of loss or theft, that you can remotely wipe the data sitting on your smartphone. Again, remember the distinction, data sitting on your smartphone, you cannot wipe what's in the cloud. The service is good for when you lose or have your smartphone stolen, so nobody can abuse it, but this can also be used by criminals, of course. And there have been cases, I've seen that the discussion has been flaring up in the fall of last year in the US. It is now coming over to Europe. How is law enforcement supposed to react to this? Criminals who feel that they're under investigation, who may be arrested in the next few minutes or next few days, wiping the data off their smartphone, which you have heard today can contain highly necessary data for the investigation. They can do it themselves, or they can have an accomplice who is notified and wipe out the smartphone even when the criminals are already in arrest or in custody. So what is law enforcement supposed to do here? They should secure the evidence on the smartphone, but how? If they are able, in a concrete case, to physically have possession of the smartphone, they may be able to take out the battery, they may be able to take the smartphone and put it in a secure box or a secure bag. In the case that was mentioned before, Riley versus California, these notorious Faraday bags were mentioned. These are bags with certain type of aluminum foil that blocks the system, makes it unable for the system, for the remote wipe to get through to the smartphone. But this is only useful when law enforcement authorities have been able to physically retain the smartphone. So I was thinking, isn't this too late? Can we do something, or can we come up with a certain, with a certain measure that can secure the smartphone at an earlier point in time? Of course, not losing sight, not losing attention of necessity and proportionality. And then I was thinking, if there is a possibility, and this is actually an idea, this is a question that I would very much appreciate your feedback on. Is there a possibility to remotely freeze a smartphone? And I'm not speaking of freezing here in terms of what happens when your smartphone, when you're downloading too many apps and it's simply not functioning properly. I'm speaking of freezing of evidence, defined as securing evidence and avoiding to have it tampered with, have it moved, have it destroyed. It is a step that is prior to confiscating. So it's actually freezing evidence, securing evidence with a view to confiscation. And in the EU, there's actually already a legal framework for this. I'm not sure of the US. Maybe you can speak of that. In the EU, in 2003, a framework decision was adopted where under the mutual recognition program, member states had to implement legislation executing orders for freezing evidence coming from other member states. So legally, we should be able to do this. I'm just not sure of the technical side. So if there's anybody in this room who can help me with that, I would very much appreciate your feedback to this. And that brings me to my last point. Because of course, when we're speaking of remotely freezing a phone, a smartphone, that again implies law enforcement cooperating with private companies. And now I come to something that a few days ago I would never thought I would actually say here. When I used to do talks and presentations on data protection, one of my arguments was always, when the topic of private companies would come up, I would always say we can only get privacy and data protection to be significant when it becomes a competitive advantage. When privacy and data protection becomes a selling point, that's when private companies will have an incentive to create privacy protecting and data protecting devices and products. But yesterday I was really astonished with the panel in the big room, where actually privacy as a competitive advantage was in the title, that more and more companies are actually developing these kind of products. And then I became a little bit nervous. As a data protection researcher, I would have to say, hooray, congratulations to these companies for developing phones that enable you to make fully encrypted phone calls, for creating these small orange boxes that you can use as your own private server, not being dependent on any cloud services. As a data protection expert, great. As a criminal law researcher, that makes me nervous. Because it can be a great idea to have such a server, not being dependent on iCloud services. It can be a great idea to have such a phone with encryption if you are a nice, law-abiding citizen who is only concerned with his or her privacy. Not so great when your daily activities include child pornography, or planning a terrorist attack, or manufacturing counterfeit medicine, to just give a few examples. Now law enforcement is confronted with another problem, cooperating again with private companies to deal with this other issue, these fully safe, privacy protecting products. And that would be a working point. And with that conclusion, I will finish my talk here and look forward to your feedback. Thank you.
Yeah, so there seems to be a lot of work ahead of us. I'm not only working for Microsoft, but I'm also a researcher writing on law enforcement access, and I had a chapter in the last in the book, and it is kind of like privacy enhancement technology, encryption. I was writing this, and then Charlie Hebdo happened, and then I was thinking, should I also include another perspective? I'm really conflicted because I also attended CPDP panel on the crypto wars as a spectator, as the audience, and everyone seemed to be of the opinion, you know, breaking encryption and forcing companies to break encryption is completely stupid, and that might be true, all right? But there are those concerns. Now, let's move on to Mike Olmsted, our last speaker. Might take it back to the US. I started with the Riley case, a short summary of that, but Michael certainly has more on the US law and policy.
Thank you. Despite not being an academic or a researcher, I also asked myself, why? Why should we talk about Riley versus California? Because to an American prosecutor, frankly, Riley versus California really focuses on when can a search occur in the absence of a warrant that is justified by the argument that it was incident to an arrest and therefore principally supported by security of the officer who's doing the arrest. And so we tend, as prosecutors, as litigators, to minimize kind of what this is getting at. It's important, however, if you read Riley versus California, to read two parts of it that are not typically discussed. The first is the facts of the companion case, and the second is Justice Alito's separate opinion, because I think those are both far more provocative. Let me make one observation before I get to those two provocative points. While Daniel was talking, I took my smartphone, I checked my emails that are in Washington, D.C., I checked my stock, which includes a medical device company in Israel. I checked the weather at my in-laws' summer home, and then I returned to this room. All of that on my cell phone. And so you can imagine what wealth of information occurs on a cell phone, the very complicated issues that come up about where the information is that appears to be on the screen of my cell phone, but is actually in Hyannis, Cape Cod, or in Israel, or in New York City, or in Washington, D.C. And the depth of that information is what makes it really complicated. And that brings us, in my opinion, to Justice Alito's decision, or not decision, his opinion. And what his opinion says, basically, in my reading of it, is we're coming up with separate sets of rules. That we have a rule for the wallet that I hold, that I keep in my back pocket, so that a policeman may search everything in my wallet. And if I had a not-so-smartphone, the policeman might be able to search the not-so-smartphone. But there is a new rule that he can't search my smartphone. Now, when I first read this, I thought, well, it'd be interesting if the police had only done what you might think of as a surface search, you know, a very preliminary search. You know, not quite as surface as looking for fingerprints, which of course a policeman would be allowed to do, because you can fingerprint the scene of a crime. But let's just say he looked at the last 30 calls. So that's the kind of thing a not smartphone can do. And that's what makes the Riley case interesting. Because the companion case to the Riley case, which is Worry, and it is decided in the same case as Riley, has some interesting facts that I think are worth keeping in mind. Worry is observed selling drugs by police and arrested. He has a phone on him that is ringing while the police are arresting him. And it says, "My home," on the screen. And so they open it up to see what number is associated with my home, and they find what that number is. They then check their own databases to figure out what is the home address of that telephone number. They then get a search warrant to go into that home, which is authorized by a neutral and detached magistrate based upon probable cause to believe that evidence is going to be in that house, and of course they find it, and he is charged with drugs and arrested. I have to say, before this case came out, I would have advised the police that they could do everything they did. I suspect, I'm not an expert on the national laws of every EU country, but I suspect that what the police did is permitted under the national laws of EU countries, that they would have been able to open up the phone, see what the number was that was ringing while they were doing the arrest, close the phone, and then go get a search warrant based on that information. And so we are coming up with rules that aren't just new in the United States. They're going to be new if they are translated over to the European Union. They're going to be new everywhere. And the problem that we see as practitioners and not as academics is that a policeman, when he goes out to make an arrest, has to be able to know what he can do or she can do and what he or she cannot do, because they want to comply with the law for a lot of reasons. One is they believe complying with the law is important. That's probably what made them police. But also, they don't want to ruin a case for an inadvertent violation of people's rights. And so, we want to be able to tell them, what can you search and what can you not search? And the answer is, I can search the wallet but not the phone. And it's not entirely clear why that's true. And so I think the task, and academics are going to help lead this task, but so are governments. The task is to figure out how to give common sense advice that people can follow and understand, that tells them when can they go into a phone and when can they not. Now, the interesting thing about worry, the case with the flip phone that just says, here's the number that's calling you, is the wide open invitation in this opinion that they might next time argue exigent circumstances, which in the United States is an exception to the warrant requirement, which is, if I don't do this now, I'll never be able to do it. There is evidence of a crime right here, right now, that will be gone forever if I don't do this. And if you can justify a search based on that argument, you can avoid a warrant requirement. And it'll be interesting to see what that means as time goes by, because I think that is a very open invitation in the decision, and I think it is one that you will probably see a fair amount of litigation about in the next 5 years, because I don't think this will be sorted out quickly. I know that everybody probably has more questions than we have answers, so why don't I just pass back to you and let you run the show.
All right. Thank you, Mike. Actually, I'd like to do the same thing, ask a question first and then ask the panel if it has questions. So, and jumping off from basically Mike's last words were gone forever. And while that's maybe a good movie title, one could also think, combine it with else and think, well, isn't freezing maybe a solution for that, a less intrusive measure? And I would like to ask Mike first, if there is something like freezing in the United States, and then maybe have else also comment, and have also Daniel and Diana come in if they want.
Freezing, let's take the worry example. They don't know that worry has a phone.
Sorry, I have to interrupt, and I want to point out that we have very coordinated PowerPoint slides here with the eyes. So sorry.
They don't know that worry has a cell phone, and they don't know what his number is. In fact, in Europe, most people don't have contracts on their cell phones. They buy time as it goes along. And so freezing is a technically available option if you know the person has a contract on that phone, and so you can actually go to the service provider and say, Michael Olmsted has a Verizon account that he pays month to month, and it covers these numbers, and can you get the information that's associated with that number? But that's not how most criminals use their cell phones. And in fact, in much of the world, that's not how anybody uses their cell phones. And so freezing ahead of time is just is a practical matter, probably not that possible. The second problem is that you're not worried that you're going to lose what is this guy's home telephone number. What you're going to lose is the ability to search his house to get the drugs that are there, because as soon as his friends find out he's been arrested, the drugs will be gone. And so what you need to do is get the search warrant quickly. And you can't get the search warrant quickly until you can figure out what his home is. And you can't figure out what his home is until you look at the telephone number. And so it's not so much that you will lose the digital data. It's that the loss of digital data or the delay in obtaining digital data will lose evidence of the crime. So that would be, I think, how most of us would think that problem out.
Any comments, maybe else?
Yes, freezing is a security measure, basically. It's securing the evidence from anything happening to it. And the typical example is in a case of printing false euro banknotes or any other currency banknotes, that the copy machine or the printer that was used in this crime is completely sealed and is locked, and so nothing can happen to it, while in the meantime a confiscation is organized, especially when it's a cross-border case in the EU.
Yeah, and then I would think this new word I learned in preparing for the panel, the Faraday bag, which is kind of this aluminum foil thing where they put in the phone so it cannot connect, that would be an answer, but maybe not. Any other questions from the panel to panelists or remarks?
Well, in fact, what I'm going to say goes a little bit on a different direction, but listening to what Mike said, he said what it would be important is that the police officer knows what he can or he cannot do in that moment. And I mean, my first thought was that there is indeed a great need at the level of the police and of the judiciary in the member states to work more on training, which is a sideline in this discussion. But I mean, my experience, we have done a lot of training for judges and prosecutors in the member states, is that most of these people know very little about data protection, and that you need to work a lot on that. But I would say this would bring us also to the discussion about the differences in the legislation in the member states, certainly in the area of criminal law, but this has even a deeper element, which is of course the big differences in the criminal law legislation, which else is the expert here, not me. But I think indeed, in as far as all these issues are not harmonized, and they will not be harmonized because are not within the EU remit, generally speaking, you will find all these differences. And it could be very well the case, and that's something we face on a daily basis when we discuss with our judges and prosecutors at Eurojust, that what is legal in a member state is not legal in the other member states. So you need to have the expertise of the national authorities to tell you, yes, in Portugal you can do that, in Spain you can do that. And it depends also on the type of crime you're investigating. You would have different rules and measures what is possible. So I think the complexity of this area is huge, and I don't think even us around the table could be able to answer all the elements of this equation.
Thank you, Diana. Now then, let's open it for... On the very back, there was a question. I see. Oh, good to see that. I think you were first. And then let's take the gentleman at the front row here.
Thank you. I'm Peter Swire. I'm a law professor at Georgia Tech in the United States. My question is a common technical thing that can come up. So sometimes you get a phone and it's open. You don't need a password. But often somebody has a passcode for the phone. If the person who's been arrested has a passcode in the US and in the EU, what is the law and what do you think the additional measures are to be able to have the person give the passcode or take technical measures to try to get in without the passcode? What is the state of law, do you think, when these fairly common technical barriers exist?
I'm looking at else.
In an entity of 28 member states with 28 different national laws, I'm afraid that I'm also not qualified to answer that question. My feeling says that may not even be regulated in every single member state, and may be a high point of discussion in several member states, but maybe my colleagues here have other experiences.
Well, I also cannot answer the question because it is, in fact, that in the 28 member states it's differently regulated. We have some member states where there is an obligation of the suspect to give the passcode, and in others, in other legal systems in the EU member states, there is the right of the suspect not to give this. Yeah, and that makes it, because you started and said, well, maybe this is a technical question, that makes it particularly difficult for national law enforcement to work on this, in particular in the area where Europol works when it's about multinational cooperation and you have an ongoing investigation that involves 2-3 EU member states. You have also to be aware what kind of law exists there, and it makes it sense now to advise to go for this seizure of the smartphone if at the end it's not, it is encrypted and you are not even allowed to ask for to get access to the phone. So it's very difficult. I think it goes together with that. What we said at the end of the panel is that we need, and what mainly Mike pointed out is that we need that police officers know exactly the do's and don'ts. And if we don't have an EU law on this, then they have to be aware what are the possibilities in their own member state when it comes to the seizure of the phone. From a European side, it's difficult, of course, to comment on this because the smartphones that we get, they are seized by national law enforcement, and we see that there are different conditions for that in the different member states. When we get the phone, and I think that I can add from my side is when we have a clarification how a smartphone can be seized on national level, and the police officer knows what kind of conditions he has to observe to seize it, I think there should be a common standard in all the member states. What do we actually do with the smartphone? So how we ensure the chain of custody of this smartphone. What I said at the beginning, an obligation to, for example, to keep always a full copy of the image of the smartphone to ensure the forensic process, to document each step of the process, what you actually did with the smartphone, so not just looking at the smartphone, seeing what is the last call, but to document every step that you do from the reception of the hardware till the final report. I think that would be next to, let's say, the guidance to the police officer, that he or she knows what he can do in that situation. The second step for the forensic services, that there are common standards how to deal with the smartphone. Thank you.
Thank you. So there's a question at the here first, and then maybe let's now take 2 questions at the same time. So,
okay, my name is Joe Dominguez. I'm just as a curious citizen, European citizen, and I became interested about this topic when I read this eye candy case of Pedro Bravo in Florida, when he was caught in court by asking Siri where can he conceal the body. And that was used at the time in court. So Pedro Bravo, I just Googled it afterwards, I remembered it. And my question is, to what extent smartphones can be used to mislead authorities, meaning creating alibis by not carrying them with them at the moment when they expect to commit a crime, etc.
Okay, thank you. And then let's have a second question here.
Hi, I wanted to know what we make of this demand for encryption now, and or demand for encryption keys on behalf of the EU or UK or France, and what exactly that would do to help authorities. So, are there specific smartphone apps or applications or messaging systems that are really hard to deal with when you're working with cases?
Okay. I see one more question, and then we will have a few answers. So that's please here with the red shirt, the lady.
Well, it's actually more of a comment or a question than a question. But when I saw the title of this conference, I was also expecting to hear about the use of smartphone to cooperate with law enforcement. So these ongoing calls for citizens to cooperate with justice and police, and the use of smartphones for those purposes. So if you have some comments on that.
Okay, so let's take those 3 aspects. So the smartphone to disguise, so basically maybe suspects exchanging smartphones or leaving their smartphone, using several smartphones, that kind of thing. And the second question was the encryption, so there are a number of services such as Vicker or others that are messaging services that are especially provided to not be detected by smartphones. And then the last one was more like a citizen question for cooperating with the police citizens, and any experiences. And should we just go through here, maybe starting with Diana, and maybe not all answer all the questions because we have about 5 minutes left. But
well, I will just say something about the first point. I mean, of course, one could obviously not exclude that. I mean, let's say, if people are well organized, they could also think in advance about this. I mean, I think in some of the events we saw the last few weeks, there was some of the points, I think it was in Paris when I heard that the ID card of one of the persons who was involved had been left in the scene of the crime. Well, I don't think it happened by chance that, I mean, this happened. So I think sometimes, of course, criminals might be very smart and might know how to fool around with the information, but I don't think we can exclude that. I think that's then where you need good forensics and you need good experts who be able to assess whether the information is right or is really somehow faked or whatever. But I think this, of course, could never be excluded, yeah.
Yes, for the first question, I completely agree with what Diana said. For the second question on encryption, for a moment I was thinking I have no answer, but the only answer that I can think of is the cooperation between law enforcement and these companies. These companies will, in the end, find themselves, as noble as it is what they are doing, I'm not speaking against these companies and what they are doing, but they will find themselves squeezed between privacy and what their customers expect from them, and a possible court warrant. Because if it comes down to a case where Wicker, for example, is used and can reveal significant information that will lead to a criminal investigation or that will lead further to evidence, then I think the necessity requirement will take care of that. The third question, citizens' cooperation with law enforcement via smartphones. I assume that you're thinking of developing apps to make to file a suit or something, or to make a complaint with law enforcement, or vice versa, as these neighborhood watch networks work, that they call you when there has been suspicious activity in the neighborhood, that this would be coming through an app to your smartphone. I have no knowledge of such apps being out there, but I can imagine that's an option. That's actually a very good idea. So maybe if there's some app developers in the room.
Thank you. I just wanted to mention 2 points. The first one was related, I think, to the question when data that is stored on smartphones are hampered. I understood this like that. So if I talk with our forensic experts, they always say to me, if we get a smartphone at that moment where we seize the smartphone, we prevent that it is remotely wiped. For us, it's important that the smartphone data stays as it is at the moment we get it. And they compare a smartphone with the crime scene. An investigator also doesn't want that in the crime scene anything changes. I'm not 100% sure if I understood your question, but that is what I've been told by the ones that are dealing with the smartphones in my organization. The second point, I think, or the last question that was asked, I think is a hint for the CPDP. I think that what you mentioned is an incredibly interesting topic. I think even deserves for the next year's conference own panel. I see two major, when we talk about law enforcement and social media, I see two major topics. The first one is, in which way should law enforcement allowed to use social media to communicate with the citizen, which should be, which is a very powerful tool to communicate between law enforcement and citizen, but leads to question out what are the legal conditions, for example, to put most wanted list on a social media. I mean, there are a lot of legal questions surrounding that. In some of the member states, you need a decision of the judge for this, and others not. And in some of the member states, it's not even allowed to do this. That's the one part. The other part is, of course, which more relates to the operational work, in which way law enforcement should be allowed to also have access to data and social media. So might be something for the organization of the conference next year to consider that.
I'll take your questions in reverse order. The ability of witnesses to crimes to videotape those crimes as they occur and hand those over to the police by uploading them to the police or emailing them to the police is a great thing. that you see a lot of cases are made specifically because there is some witness who is using their smartphone to take an image of what is happening in front of them, so that instead of their vague memory 3 years later about what people looked like and who took the first punch, or whether or not they actually saw the money pass hands, or whatever, or the police beat Rodney King, or whatever is the crime that you're looking at, the ability to show it to a jury or a judge 7 years later or 3 years later in a courtroom is huge. And so the value of smartphones, and it's really just to lock down what does a witness see, is a really valuable thing. On encryption, because the answer to Peter Swire's question in the United States is that you can't get someone to testify against themselves, and so you can't get them to tell you what their encryption code is. The need to work with companies in order to be able to have a encryption key available to law enforcement from the companies is something that we care a lot about, and it is an active public dispute in the United States on whether that is an appropriate thing for companies to do or not an appropriate thing. And I guess the last chapter isn't written unless I missed that class. And the last point is, can people use smartphones as a clever way to create false leads and to give themselves alibis and all that kind of stuff? And the answer is yes, completely. And it is our job to figure out why it's a false lead. And I can tell you this, we are smarter than the ones we catch, and we are not as smart as the ones we don't catch.
Thank you very much, and thank you for the last quote. Please, everyone, join me in congratulating our panel, and also in particular, Tobias, who managed indeed to keep the panel on time and lively and interactive. Thank you.